Hello, everybody. We're a couple minutes out from our start time. I'm Rich Rylander from UCEDA International, and it's great to see all of you joining. And hello, everybody. We're a couple minutes out from our start time.
Hi.
I'm Rich
Hi.
Rylander from International, and it's great to see all of you join. Let me see, I've got a little bit of background noise. All right, I think I've cleared that up. So, as I mentioned, I'm Richard Rylander. I'm the Vice President for UCEDA International, a School of English as a Second Language, which has been teaching English to people from all over the world for more than 30 years. We have with us today a few special guests. Nuran Galal, our International Marketing Director, and also we've got a couple of representatives. I know Luca is here from VisaServe, NPZ Law Group. Hi, Luca. How are you?
Hi, how are you?
Great to see you. Is anybody else able to join from your firm also?
Hi, Richard. How are you doing?
Oh, there we go. Hi, Samantha. How are you?
Hi, good.
Can people maybe mute themselves?
Yeah, as the host here, I'll be muting people remotely in case there's some background noise.
Richard, can you let me be co-host so I can do PowerPoint?
Yes, absolutely.
Perfect.
All right, that should have gone through now. So Ludka Zimochak, is that how you pronounce the last name?
Perfect.
Yes, this is the Z in NPZ Law Group, correct?
Yes.
And NPZ Law Group has been helping us for many years with some of our more complex cases when we have students or prospective students that are interested in a change of status. Many times it's a simple process and we can help with those. Sometimes the process gets a little complicated with a deadline that was missed perhaps, or a request for evidence that gets a little complicated. So oftentimes we've referred those cases to NPZ Law Group and they've done a great job helping us. Today they're also going to be talking about the road to the green card and how it's possible once you have your F1 status to apply for or prepare for a green card potentially in the future. So I'm really glad that we were able to set this up and that we're going to be able to hear from you and learn from you today. Aside from a few of our staff, we also have several students and prospective students that are joining us for this webinar. And we have even a couple of faculty that reached out to me and said, hey, can I attend this webinar also in terms of professional development? Can I learn more about these visa processes? I said, absolutely. So we've got a variety of different people that are joining us today.
Yeah, it's a very interesting topic for everyone, honestly. Like students who wants to pursue their journey, getting a green card and pursue more opportunities in the USA. So we always want to encourage our students from all over the world first to come to America to study English, and then to pursue their green card. And with your help, Lutka, I'm pretty sure they can get this opportunity.
Yes, thank you so much. This is really, really great that you guys set it up. It's really helpful. Do you want me to start? Should I introduce myself or should we wait a few more minutes?
Let's wait a couple of more minutes for everybody to come in.
I see people are joining as we speak.
Right.
Yeah.
So I'll do a little bit of housekeeping introductions. This is a Zoom webinar. We're also broadcasting this live on our YouTube channel. As a courtesy to everybody involved, we're asking those who are joining us to please mute yourselves as you enter the meeting. If we hear background noise, we will probably be able to mute you as the host of the meeting. I can probably mute you, but if you can mute yourself, that would be ideal. And then there will be an opportunity, I think, at the end of this for a little bit of question and answer. We won't be able to get into a lot of case-specific issues, but we can talk in generalities. And we'll definitely take note of your contact information if you want us to reach out with some follow-up information. Either somebody from the UCEDA team or somebody from NPZ Law Group can reach out to you for additional support. And I believe all of the UCETA students that are attending today, if you're interested in any services from the NPZ Law Group, by participating in today's webinar, you'll be eligible for a discount for their services.
Yep, absolutely.
All right, great. And again, for those who are just joining, my name is Richard Rylander. I'm the Vice President for UCETA International. This is a school that's specialized in serving the needs of F1 visa students through intensive English programs here in the United States.
The definition of these parts of speech.
So here,
in the box saying that
we have a little bit of background noise. I think I got it. All right. So UCETA International offers intensive English programs throughout the state of New Jersey, as well as in Connecticut and in the Washington, D.C. area. So if anybody is interested in studying English as a second language and having an important life experience here in the United States, they can contact UCETA International for information on the F1 visa process. And once you're here in the United States on the F1 visa, there are a lot of different opportunities for you. After you complete your intensive English program with UCETA, you can go on to study in a college or university. You can return to your home country with a language skill that will help you to advance in your career in a lot of different ways, to interact with people across the globe. And you can also find ways to apply for a green card actually in the United States. And that's what we're here talking about today with Ludka from NPZ Law Group. So I think we're about 5 minutes into this, Ludka. I think you can go ahead and get started.
Okay, thank you so much. So again, I think this is really great opportunity for your students. So thank you for inviting us. You know, the purpose of, well, let me just introduce myself. So my name is Ludka Zimowczak. I'm partner at NPZ Law Group. Our firm only does immigration. So anything involving immigration, could be family immigration, employment-based immigration, removal. Hopefully nobody has any issues with removal. Asylums, we see a lot of asylum cases. So anything involving immigration. We have clients all over the US because of course it's a federal law. We have clients abroad in different countries, so they're coming to the United States either to study or work, or artists, Olympians. Just yesterday, I got a new case, somebody who won Olympic medal. So immigration is really interesting. I love it. I've been doing this for about 17 years. I'm immigrant myself, so I came as a student as well. So I totally understand everything, and I wish I had someone who would do presentation for me when I was in school as a student. So students are usually very busy with the school and maybe don't have time so much to think about future immigration, but it's really, really important. And that's what we are going to be discussing today, just to kind of start you thinking about what your options are, what can you do in the future. And I'm gonna introduce Samantha, who is my colleague and will help out today because I know David was supposed to join, but he happens to be in India and he's meeting, you know, with all the clients in India. So Sam, do you want to introduce yourself?
Yeah, thank you. So my name's Samantha. I'm one of the attorneys at NPZ. I work out of the Fort Lauderdale office, so I'm here in Florida. If anyone wants to come for some warmer weather down here. But I do work with Ludka on a lot of these cases. We try and help students as best as we can, try and find that right route for them to the green card from the student visa. But as she mentioned, people have all different situations. We deal with people that have asylum cases, removal cases, and we try and help everyone as best as we can. So hopefully throughout the presentation, something will sound interesting to you, and you can always, of course, ask us questions. While Ludka is presenting, I'll be monitoring the chat. So you can feel free to ask some questions in there. If it's a personal question, I just would ask that you either send it directly to me or to Ludka, or hold off and send it via email. But other than that, we look forward to working with you guys.
Yeah, we'll try to leave some time at the end, but I think it's more fun if you ask questions. So feel free in the chat. So feel free to just write questions if you don't understand what we are talking about, or you want to have more information on whatever topic. So let's start. This is probably one of our most dear and significant and most important slide. Any new client that we have, we always start with that slide. Of course, we don't have slide in front of us, but this is the discussion we would have. You know, we may have a client who has no status at all. Either they were students and they fell out of status, or they entered without status completely. They crossed the border, or we have clients that were brought as children and now they don't have status. So, you know, there are options for them. I'm going to let Sam in a little bit discuss that, but, you know, immigration is a life cycle. And we go through different stages with immigration. And typically, when we have a student, they will ask, how do I get citizenship? I want to be US citizen. So, and we, at that point, we go through that slide. We discuss how you become, you know, someone who has more stable non-immigrant status. Once you have that, you move on to immigrant side, which is a green card, and finally citizenship. So we'll go from the start. So I'm gonna let Sam just explain a few examples, you know, that we have for people that have no status. And hopefully everyone has legal status, hopefully F1 or J1. But if not, you know, there are options as well. So Sam, I'm gonna let you explain.
Yeah, perfect. So I mean, like Ludka said, I'm sure a lot of you do have F1, but you may have friends or family that don't have status, and what are the options for them? So the first thing we do when we're meeting with a new client is we understand what their current status is, and we try and figure out the best route for them going ahead. Some options that could be available are DACA. DACA is for children that were brought here at a certain age. Before 2012, they needed to have been in the US on a certain date. And it allows them to receive benefits such as work authorization. They can go to school and they can stay in the US for as long as they're renewing that DACA. Right now, I'm sure you've heard about DACA in the news. It is still alive. We are able to file DACA applications, but unfortunately only renewal applications at this time. We're hopeful that that might change, but we'll just need to be patient with that. Another option is a U visa. So U visa is for victims of crime in the US. There's certain crimes that qualify to be able to get an individual a U visa. And if you apply for the U visa, you would, you know, essentially create a pathway to a green card and thereafter citizenship. And you can include your spouse and your children on that application as well. So a lot of our clients really benefit from that form of relief. The benefit, in my opinion, of a U visa is that you don't need to have any valid status in order to apply. And you can also waive a lot of the traditional issues that we see with, you know, immigration. So it can waive, you know, an unlawful entry. It can waive a removal order. And so sometimes a client comes to us and feels that they're hopeless, and the U visa, it's a good option for them. 245I benefit, what that is the ability for someone who maybe is here without status, or maybe someone who entered the US without status, to be able to apply for their green card in the US as long as a petition was filed on their behalf or on the behalf of a parent of theirs on or before April 30th of 2001. And that's a very specific date, but we have found even recently clients who were able to benefit from that. So if you feel that, you know, maybe right now I don't have status, but my parent might have filed something, you know, 20 something years ago, or my grandparent, we look into their immigration file, and sometimes they are able to file for a benefit in the US. So it's always possible, and we always try to explore every possibility available. And then the last thing mentioned here is asylum. I'm sure a lot of you are familiar with asylum. Asylum is for victims of crime. Asylum is for those who are afraid to return to their home country because they either were persecuted or fear that they could be persecuted if they go back. Asylum is a little difficult to do right now, especially with all of the constant regulations. However, it is possible, and we would need to show that the persecution was as a result of your race, religion, nationality, political opinion, or membership in a particular social group. We would need evidence. We would need to show proof of all of that. And eventually it could give you the green card and thereafter citizenship. Just very quickly, asylum does have to be filed within your first year of arriving in the US, unless you meet certain exceptions. And maintaining a student visa is an exception. So it's something that we should definitely discuss if you are considering filing for asylum. Timing is key. And so if you are, maybe finishing your student visa and afraid to go back home, it's something that we should explore to see if that could be a potential option for you after your schooling ends.
Let me just interrupt here, and very important, especially if you're students, so obviously you have status, so asylum doesn't apply only to those that have no status. It's always better if you maintain your F1 while applying for asylum, because if anything happens with your asylum, if you have F1, nothing happens. But you just rely on your asylum, you let your F1 go, and your asylum doesn't go well, you're going to be referred into immigration court, and that's no fun. So if you're a student, you are thinking about asylum, you should definitely do it, but make sure you maintain your F1. And the same goes for TPS, which is temporary protected status. Right now, there are a lot of countries, I think 11 or 12 countries. They keep expanding. I get a lot of questions on that from students specifically. For example, Nepal, Venezuela. I believe that there is a push right now for Pakistan as well. So let's see what's going to happen with that. But the key is try to maintain your F1, because if the TPS ends or something happens, is denied, or at least you would have some other status to fall onto. So it's definitely better. So with both, for example, asylum, people get excited with asylum because they get work permit, but you need to think long term. If you don't have a good asylum case, that could bring you into immigration court, and then you can be potentially deported. If you have valid F1 status, nothing happens to you.
Right.
So
and that's okay. And it's not whether or not you have a good asylum case. At the end of the day, it's up to the discretion of the officer. So if they're not 100% convinced that your asylum is a slam dunk case, then they sometimes err on the side of caution and say, well, you know what? I don't want to be the one to make that decision. Let's send it to the judge for them to make a final ruling. So you could have the best case in the world, but it's really up to the judge, up to the officer, and thereafter the judge at the end of the day.
Thank you, Sam. And
Yeah.
of course, if you are, whether you're a student or you have no status, so either if you have F1 or no, if you're married to US citizen, whether you have status or not, you would be able to get benefit, assuming that you entered with inspection. If you entered without inspection to the US, so you're here without status, no inspection, then your US citizen spouse would be able to do a 601A waiver, which is hardship waiver. So that's a different discussion altogether. So these are just some examples of options for people that have no status. Hopefully that's not you. So let me just move ahead and go into non-immigrant visa category, because that's really what we are going to be discussing today. So within non-immigrant visa category, we do have classification that we call pure non-immigrant intent type of visas. And these are students, for example. So visitors, B2s, J1s, that's a pure non-immigrant intent type of visa. So when you applied for your visa, you had to demonstrate that you have strong ties to your home country, and also you're not planning to immigrate and stay in the US. So if you let's say if you would be entering the US and the officer will ask you, what are you planning to do? And you would have said, oh, I love US. I think I'm going to stay here permanently. I can guarantee you that you would not get admission and you would be returned right back. So these are just visas that are for temporary period. And as I said, you should not really be applying for green card, and you shouldn't have immigrant intent. We do have a second subgroup within non-immigrant visa category, and these are dual intent visas, and that's what you want. So if you are an F1 student right now, and you are thinking that after your studies, you may do bachelor's degree, or you may pursue associate degree and so on, and later you want to work here. So you should start thinking about switching to dual intent visa category. Perfect example would be H-1B. So again, not the best strategy to go from F1 to green card directly. There are exceptions, of course, as with everything. So for example, I mentioned marriage case, or you may have a relative that already filed a petition for you. But typically you would want to switch to a more stable dual intent visa status. For example, L, that's a good one as well. We talked about H-1B is a good one. R1, religious workers. These are just few examples. Once you have that dual intent visa status that will allow you to work in the US, then you can move on, start thinking about with the green card. There are several different types of a green card that you can do, and you can do that at the same time. So for example, if you have a family member, mom or dad that is a US citizen or green card holder, or you have spouse that is green card holder, you can definitely do family-based green card petition. At the same time, you would be able to do employment one if you qualify, and you can do several. So for example, we have EB1, 2, 3, 4, 5. A lot of people do EB1 and EB2 at the same time, again, if you qualify. So I think today is what, 10th. So November 7th just ended the DV lottery. So, obviously just ended, but for next year, you can definitely do that. And as a student, you can do it. It's not considered immigrant petition. So you can try your luck with the DV lottery as well. It only runs from beginning of October. This year, it ended November 7th. So you can try as many types of green cards as you want to if you're eligible, and see which one goes first. Once you get your green card, then you either stay with the green card. We have clients that never apply for citizenship and they just stay as permanent residents. So that happens after 5 years of having green card. And if you're married to US citizen, it's after 3 years. You always have to check with your home country if that country allows for dual citizenship. That's important, because you may lose your own. So US does, so that's not a problem, but check with your own country. Okay. Did I miss anything, Sam?
I don't think so. We are getting some questions in the chat just about, how to switch visa categories.
Okay, let me go ahead. So this is the typical path for most of the people. So of course, F1, once you're pursuing F1, that, where you get a degree, so you get associate degree or bachelor's degree or master's degree, you are able to apply for OPT, which is optional practical training. That will allow you to work for 1 full year. If you have a STEM degree, that will allow you to work additional 2 years. So again, if you're going to be in the future in a STEM degree, you're going to have 3 years of work permit, which is great. And that would give you enough time to have your employer apply for H-1B. And once you have your H-1B, you can immediately proceed with the green card. As I said, there are exceptions. So if you would have the STEM OPT for 3 years and you are from country other than India, China, Mexico, or Philippines, you potentially could go from F1 to a green card because you would have 3 years of work permit. But ideally, you switch to H-1B. Once you have the H-1B, your employer can immediately proceed with the green card. There is no wait time. A lot of people ask me, how long do I have to be on the H-1B? There is no wait time, but companies do have policies. So bigger companies have maybe 1 year wait time. They want to see how you're going to be doing on the H-1B, or 3 years. Or there are some companies that will say we don't sponsor at all for green card, or we don't sponsor for H-1B. But there is no rule how long you need to stay on the H-1B to start the green card at all. And also there are some green card categories that you can do yourself. So it's a self-petition. So that's really helpful if you qualify, because then you don't have to rely on the sponsor or the employer. So I'm gonna jump into H-1B. So we mentioned H1B several times. It's really great because it's a dual intent, and I would say it's the most common. So it's a typical path for most of the students to go from F1 to an H1B. For H1B, you do need at least a bachelor's degree. That degree doesn't have to be US. I mean, it's ideal, but you may be now pursuing English, and let's say you already have bachelor's degree or even master's degree from abroad. So that would work as well. There would have to be an academic evaluation. We don't do that. So there are separate agencies that will do academic evaluation. You could even do it now. There are many, many companies that will do it. You also can use experience. So for example, our clients from India that have 3-year degree. So that of course is not going to work. 3-year degree will be not sufficient. If they have work experience, we can supplement it because there is a 3-for-1 rule. So 3 years of experience will be considered as a 1 year of academic study. So again, this is not us. That would be the credential evaluation company that, you know, they would determine whether or not your degree is equivalent to the US bachelor's degree. So remember, you can use your foreign degree now. The key with the H-1B, you need a job offer. So you cannot file it yourself. You need a company that is willing to sponsor you. And very important, the position itself needs to require a bachelor's degree. And on top, it needs to be related to your degree. So that's very important. Examples of H-1B occupations, these are really just examples. Chemists, these are easy, engineers, biologists, but there are many, many different occupations. In fact, Department of Labor has the list of different occupations that we look at just to see what are the minimum requirements for the position. Because again, even if you have a master's degree potentially, if your position that's been offered to you doesn't require a bachelor's degree, then it's not going to be approved. The H-1B will not be approved. So the key thing that we are looking at, does the position require a bachelor's degree? Do you have at least a minimum of a US bachelor's degree? Is there any relation between your major, your degree, and the position offered? So sometimes, as I said, these are easy. Chemists, usually we have people with chemistry degree, but there are some cases that we really have to be creative. We call it creative lawyering, where we actually do go and we look at the actual courses to see, you know, how we can connect those courses to the offered position. So many different occupations. For example, if, as I mentioned, if somebody has a master's degree, they come to us and they will say, and it happened, I have a job offer from a gas station. Sam, is it going to work?
Absolutely not.
Okay.
Absolutely not.
But it may work. I actually had a client where it worked because the owner had several gas stations, and the applicant actually was doing, now I don't know if it was a budget, something with the finances. So it worked. So of course you cannot pump the gas.
On first glance, you would say, no, it wouldn't work,
Yes.
But you really need to dig into it. And I think that's what you're trying to explain, that, you know, you need to look into the job duties. You need to look into what's required for the program, what's required for the job, and really just make an evaluation. So yeah, that's a good example.
Yeah, it's not, I mean, we do it on a daily basis. So pretty much typically when I look at the position and the job duties, I can tell. If not, as I said, Department of Labor has ONED, which has all the occupations and, you know, minimum requirements that we check. There is also DOT Dictionary of Occupational Titles that we check. What are the minimum requirements? So there are ways definitely to check it. But as I said, it's, you know, it needs to go case by case when we are looking at, you know, whether or not somebody qualifies for the H-1B. Let's see, next slide. So let's talk about the H-1B process, and then I'm gonna just skip that and explain to you why we have the lottery. I think this is very important. So H-1B is great, but the problem with the H-1B is that we don't have enough H-1Bs. There are only 65,000 H-1Bs annually per year. We have additional 20,000 H-1Bs for those that have US. Here they have to have US master's degree or higher. So in total, we have 85,000 H-1Bs. And just to give you an example, this year, so in March registration, there were close to 500,000 registrations. So I remember the times when there was no lottery. I think it was around 2008 or 2007. So we just had H-1Bs available all year. But every year since then, there is just more demand every year. And this is the most I have seen. And I've been doing immigration for 17 years. So I expect next year it's going to be even more. So there's definitely better chance for people that have US master's degree compared to bachelor's degree, but it's really just luck. There is no, it doesn't matter what country you're from. It doesn't matter what degree you have, what position, it's pure luck. So I have actually this year, I had a client with foreign Indian bachelor's degree, and he got in the first time. And then I have PhD student who does cancer research, and this is the third year that he didn't make it in a lottery. So totally luck. So let's talk about the process, how exactly it works. So there is this registration process. It's pretty new. This was the third season that we've had it, and I think it works pretty well. I like it compared to what it was. The employer, so it's again, not you need to have employer who is going to do online registration. That happens on March 1st. It happens only once a year. So starting on March 1st till March 18th, so about two and a half weeks, it's only $10. There are no documents, just some information that employer will have to provide and submit electronically. By end of the March, we would know who was selected in a lottery, and only those that were selected will be able to file the H-1B starting on April 1st. So I have a note here that, there was a second lottery and even third lottery, but this year, actually we didn't have what happened. We were waiting for the lottery. It just didn't happen. And why? Because the government just figured out system where they initially selected a lot more. So not 85,000, but they selected 120,000. So because they knew there's going to be some people that will just not go for it. So as I said, we didn't have second and third lottery this year, but we did it. We had it last year. So I'm expecting that the same is going to be next year. So if you're thinking about the H-1B, in case you do have equivalent of the bachelor's degree, here is the registration period, March 1st to March 18th. Filing of the case is April 1st up until June 30th. And the actual H-1B, once approved, will start on October 1st or later. If you are a student, and let's say your status will end, I don't know, in June or July, your OPT. You can use CAP-GAP extension, which is great. That was something that was implemented around 2009. If you don't have F1 status, that for some reason you're on a different status, I don't know, J1 or some other status, or maybe you have a spouse and you are on F2, you have to figure out your non-immigrant status up until October 1st. So the fact that you're filing, let me give you an example. I had some applicants who had tourist visa, so they entered as a B2 visitors. They were applying for the H-1B. So just filing the H-1B in April or May is not too helpful because they need to have legal status up until October 1st. Because as I said, the H-1B really starts on October 1st. If you're an F1 student, you have the OPT, and that OPT expires but you filed the H-1B prior to that, then the CAP extension will apply, and you will be able to stay in the US and continue working up until October 1st. It's a very specific scenario. Okay, do we have any questions, Sam, that are relevant?
No questions yet. Oh, well, this is a good question. So does the lottery apply for Colombia? The lottery applies for everywhere. You can be from any country, have a degree from any school, as long as it is the equivalent of a US bachelor's degree, and you can apply. It's not like the DV lottery, the diversity visa lottery, where there are country-specific requirements. This applies to everybody. That was a good question.
I have a question.
Yeah.
Yes, so does it matter what kind of business is applying for the H-1B, or any business can apply for it?
That is a good question.
This is a perfect question. I also do a radio show, and I was asked this question. Please, Sam?
This week or last week, so very recently.
Yes. So this is really great question. It really doesn't matter. Any type of there are no requirements for H-1B for the company. So as long as it could be startup, it could be huge company, it could be small company. It doesn't really matter, what are the tax returns like, because we are not even submitting them. It just has to be bona fide real business where it's a real business opportunity or real offer of employment. So the key, I would say, is that there is work available, that the company has work available. So, not an issue.
What if I open an LLC that I own and I apply for myself through my LLC?
No, it's no good, because it's not a self-employment. There has to be an employee-employer relationship. So you wouldn't have it in this case. You can have, let's say if it's a huge company and you have, you're on board and you have some ownership, that's a different story, because there is a board of directors and so on. But if you just open, everyone would be doing that because it's a form of self-employment.
Luca, one quick question for you that I think some other people might be asking. What's required of the employer for this process? Do they need to pay? What's required?
So yes, legal fees, they don't have to pay. Filing fees, they do have to pay. As far as the legal fees, they cannot deduct it from someone's salary, but premium processing, the applicant can pay, but the employer should be paying for the filing fees, because at the end of the day, they're the ones who want, the employee. And of course, the employer has to be, and I think we're going to get to it, they have to be paying prevailing wage. So there is a minimum wage that they have to pay, and we can determine that based on location and type of position and what is required. So there are 4 levels. So that is called the prevailing wage. And I think I'm going to discuss it a little bit later. Okay, so H-1B is generally valid for 3 years. It can be extended for another 3 years. So in total, you can have 6 years. And that's enough to accomplish a green card, assuming that you are, again, not from India or China. Why I keep mentioning India and China? Because there is a retrogression. So they will be waiting for green card much longer. Indian national, about 10 to 15 years. The good thing about the H-1B is that if the Indian national will start the green card within those 6 years, then they will be able to extend the H-1B beyond the 6 years. So I have some clients that had H-1B for 10 years or 12 years. So, you definitely can get time back. So whenever you leave the US and let's say you spend 2 months in your home country, you can recapture it back. And you would think why this is important. Well, just today, I'm dealing with one of my clients who is almost at the 6 years, and we are not close to the green card yet. So we actually are going to be recapturing, and he needs to count every single day in the past 6 years, whatever he spent outside of the US. And then we are going to ask the government to get the time back. So that's called recapturing. And I did mention that, you know, for Indian and Chinese nationals, we can keep extending beyond the 6 years, assuming that they start the green card process timely.
If I can jump in, I think I have a follow-up question. I think this is a really important topic about the timing and also the nature of the employer. As one of our attendees brought up, what kind of company can sponsor an employee for H-1B? And you did a great job answering that. That is a very common question. So to make sure that I understand and everybody else listening, it sounds like the applicant, the individual, cannot be a majority owner in the company that is sponsoring them. We know that that's true. And there's no minimum years of business that the company needs to have.
Correct. Correct.
Okay, but they need to show that they're a legitimate business, that they have some source of revenue, they have some employees, and they need more employees.
Well, I've done H-1Bs for companies with 2 employees, for example, and it
Yep.
worked.
Okay, great.
They
But there's no
may-
minimum.
There is
There-
no minimum. There are no such requirements. It's just you probably will be questioned more,
Right.
because they may ask, well, they're going to see 2 employees. Does the company really have work for this potential employee for 3 full years?
And
So
they-
Right, that's what it
resources to
comes
pay
down
them.
to.
Right.
yeah, availability of work. That's what the USCIS will be concerned about.
Right. And then the employer is responsible for paying for the filing fees to the U.S. government. The responsibility for paying the legal fees for the attorneys, that's a discussion that the applicant and the employer can have to decide who pays those. But in no way can the employer ask for the employee to reimburse any of the fees
Correct.
that the employer has paid. And the employer is responsible for paying a fair salary as determined by the prevailing wage. And there are websites and a lot of formal guidance about what that prevailing wage would be, depending on the nature of the work that's included in the job description, right?
Yes. And I see question about if nursing is a STEM degree. No, but nursing is a great degree to have. And actually there is a shortage of nurses. So this is even a different discussion for nurses. There is a special green card route for nurses only. It's an easier way to a green card, I would say, but it's more complicated way to a H-1B for nurses. And as far as the STEM, so STEM stands for science, technology, engineering, and mathematics, when I was talking about STEM degrees. And I also see question about a credentials evaluation. There are many different companies. For example, Morningside, now, of course, FIS, many. If you just Google credentials evaluation company, you're going to get a huge list.
I can
So-
include those links in the chat for everybody.
Yeah.
Morningside, FIS, and WES. Those are the 3 big ones.
Yeah, those are the 3 that we
Well, this
see
is
the
a
most
really
often.
good question that I see. Companies should be related with your bachelor's degree. Yes and no. So technically speaking, yes, but I'll give you one example. I have a client for many years. They have several dental offices, and my applicant, who has been working with them forever, has a finance degree. So it's not related, but they do need him. And, you know, he had H-1B for a long time. So again, it's like that example with the gas station. As long as there is a need, I mean, there has to be some type of connection, but it
Right,
needs
the
to be
position that they have is related.
correct. So as long as we can explain how does the degree and position, they have to be related. And of course, it needs to make sense why this type of position is needed for that particular business. So, you know, as my dentistry, my dentist office, you would think that it would be a dentist, and I was applying, again, I don't remember what position I applied for, maybe some type of financial coordinator or something like that, but it just needs to make sense that the business does need that position, and that's what they're offering to the individual. Okay, so let's move forward. The H-1B is employer specific. What does it mean? Once you get your H-1B, it's going to be tied to that particular company. So it's not like a work permit where you can work wherever. You're going to be tied to that company. However, once you go through the lottery and you have that H-1B, if you get a better offer and you want to change the company, you can do that. So you can transfer your H-1B. You will not have to go through lottery again. And it is definitely easier. So we say that you can port, which means you actually would be able to start the new job just with the H-1B receipt notice. Even though I don't recommend it, it's better to wait until your H-1B transfer is approved. There is premium processing available. You pay government $2,500 and they'll make a decision in 2 weeks. Very important. And for some reason, I get this question all the time. Part-time H-1Bs are fine. It doesn't have to be full-time. So you could have an H-1B for 10 hours per week. That's fine. And that brings me to another point. Concurrent H-1B is allowed. So what is that? I have a lot of clients that work, for example, for IT industry. So they work for some private organization for 40 hours. And then we do concurrent H-1B for university to maybe teach 5 hours per week. So, this individual would have 2 H-1Bs, one for university and then, in tech company. So it's absolutely okay. But, you always need, you can even have 3 H-1Bs. That's fine. Totally fine. Okay. We talked about cap. Exemptions. So that's important because we don't have too many H-1Bs. So as I mentioned, lottery is done just once. So once you go through lottery, you get it, you have the H-1B, then you're not going to be subject to H-1B cap again. But there are certain organizations that are able to do the H-1B anytime, and there is no numerical limitation, there is no deadline. So let's talk about those. So these are universities and colleges, so higher education. They can file an H-1B at any time. So if you're thinking that in the future you're going to be working in academia, that's easy. They can do H-1B in March, in December, anytime. Then we have organizations that are nonprofit, so 501c3 organization that do some type of research. They also are not subject to the cap, so there is no lottery required. Then any organization that is affiliated with higher education, so that's possibility as well, and nonprofit organization that does government research. Oftentimes I see nonprofit organizations, that they do some type of research and they are cap exempt, but they don't even know about it. So if I'm sure you're going to ask me, well, how do I know? Well, we just have to explore it. I mean, there are organizations that do H-1B, so they know they are cap exempt, but my experiences, companies that I deal with, they usually have no idea. So the student comes to me and the student will say, I'm doing an internship for ABC company. I see that they are nonprofit. They may be cap exempt. And then we explore it together. We look at company's profile, what do they do, and so on. And then we make an argument to the government that it is a cap exempt organization and, they don't have to go through lottery. So what is the problem with those H-1Bs? So let's say if you work for a university or that nonprofit organization, you get your H-1B and then you want to transfer your H-1B. Well, you can't to the private industry because then the company from the private industry is subject to the lottery. So you would have to wait until that company does a lottery for you, a registration. And if you made it, only then you can do the transfer. The only little loophole there is, if you keep your cap exempt H-1B, for example, you work 5 hours per week for university or nonprofit organization with your H-1B, then as a concurrent H-1B, you can have second H-1B working for private industry. But the minute you lose your cap exempt H-1B, you lose the other one as well. I hope it makes sense. Okay, so this is the LCA, labor condition application. So before we file H-1B, we do file labor condition application with Department of Labor, and that's exactly where we are disclosing the prevailing wage. The good thing is, unlike the green card, here we can find the prevailing wage. So pretty much we look at the location, we look at the requirements for the position, what is required, which level, is it level 1, 2, 3, or 4, and then we file the labor condition application that of course organization is not displacing US citizens and so on. That takes about 7 days to be certified, and only then we can file the actual H-1B. Okay, so what happens if you don't make it in the H-1B lottery? Or let's say you come to us tomorrow. So obviously there is no lottery at this point. So then we talk about different options. And, you know, I'm explaining here about H-1B, how great it is. But sometimes for some people, there are better options there than H-1B. And sometimes we don't even go. Like clients come to me to do H-1B, and we decide to do something completely different. So let's go over it. Sam, do you want to tackle some of them?
Yeah, of course. So you can just jump into a few. So an e-visa is for treaty countries. There's a list on the Department of State website which countries apply, and it's for those who make an investment into an organization, a company in the United States, and it does allow work authorization. I know I just saw a question in the chat about work authorization, so it does allow work authorization to you and a spouse as part of that e-application. The L is for intercompany managers being transferred over from a foreign company to a US affiliate or a US branch office. And the L, you know, like the H, it is for 6 years, correct?
7. So L
7.
is actually great.
Yeah.
It's either 5 or 7. So L1A is
close.
for managers, and
Yeah.
L1B is for 5. And what I want to say about L, because it may not be too applicable to you guys, because you do have to have 1 full year of experience abroad for the foreign organization before you get transferred here, as Sam mentioned. But there is also something called L1, new L1A, and that's where you, let's say your family has a business abroad. You go back, you work there for 1 year, and there is no US organization. So you come to the US to open up a new business. So you are going to create new organization that will have a corporate relationship with the foreign organization. But, you know, I don't see too much with the students because students are here. But, you know, it may be applicable to you if you have that 1 year of experience within the last 3 years. So that's important, within last 3 years. L1 is a dual intent. It leads to a green card, specific green card, which is EB1 for multinational managers. And as Sam mentioned, L2 spouses have work authorization. H4, and I saw somebody ask, there is H4 doesn't. There is no work permit unless the H-1B applicant obtains, starts the green card process and gets I-140 approved. So L2, and Sam mentioned E2, it's really great. And there was a recent change, I believe it was a few months ago, where the spouses don't even have to apply for work permit, like they're automatically work authorized. So it's great.
Yeah, it's pretty great. I mean, we've seen, I think it was in January or February, but it's been really helpful since then for a lot of our clients. I'm just going to skip around a little bit. The B1, because Luca was talking about the L, the B1, if you were to come to the United States on behalf of a foreign company to do meetings, trainings, negotiate types of contracts, things like that, you could be on a B1 visa. And a lot of times I see clients coming on B1 and then switching to L, or, you know, kind of juggling between the two as to what might work best. So they kind of tie nicely together. The U visa we discussed a little bit earlier. It's for victims of crime in the US. As long as the crime occurred in the United States, there's no requirement when it occurred. So it's a nice option for a lot of people. An I visa is a foreign media representative. So let's say hypothetically you have employment with a newspaper in your foreign country and they want you in the US to report on certain issues. You can apply for an I visa that would allow you to stay in the US and work for that foreign organization. And what's nice about the I visa is that, like the F visa, it's for duration of status. So for as long as you're maintaining that relationship with the foreign media organization and continuing your employment, you're still eligible to keep that I visa intact. The J visa is a training visa. And, you know, the J visa sounds nice, but there are some downsides to the J visa. And Lutka and I were just on a call earlier today about the downsides of a J visa. Many individuals with the J are subject to a 2-year residency requirement. So what that means is, you know, it's great to have it. You come to the US or you apply for the J, you finish your program, and now you may have a 2-year requirement that you need to go back to your home country for that time before you can pursue an H or pursue any other type of visa category. So the J is great, but I would rather, if there's another option, we try and explore that instead. Let me see which ones did I not hit?
We do, you talked about E based on treaty.
But also
TN is a great one. I think you didn't.
Yeah. No, I didn't.
Treaty, and that's only for our Canadian and Mexican clients. So whenever I see that somebody has a Canadian passport, they may be born in different country, let's say, I don't know, Pakistan, and they have Canadian passport, that would be the TN. It's not a dual intent, but it's great. You just need, it's super easy. You will need a job offer, of course. So it's not self-employment from the employer. And there is a list of occupations. So for example, accountant, lawyer, engineer, biologist. There is a whole list of occupations that would qualify for TN. But for Canadians, they just go to the border and they show the offer letter, they go through interview, and they get the TN. That they can get it for 3 years, and it can be extended in 3-year intervals forever. So it's really nice. E3. So E3, it's similar as H1B, but it's only for Australians. So it's for professionals, the same as the H1B in specialty occupation, but again, it's just based on treaty for our Australian clients. I also want to point out that for visa purposes, like we are discussing now, you could be dual citizen and we can pick, whichever we want to use. But for the green card, it goes by country of birth. So if you were born in, I'm going to pick India again. If you were born in India and you were 1 year old and then your family moved to Canada, so you don't even know India, you don't speak the language, unfortunately, you would still be considered as Indian national for green card purposes because they go by country of birth, okay? But for visa purposes, we look at whatever passports you have. Like a lot of our Venezuelan clients have Italian passports. So it means that they are eligible. I would immediately think about the E2 because Italy has a treaty. So there is E2 investor visa. So it's great. Did you talk about P visa?
I don't think I spoke about P visa.
Let me hit, yeah. That's my favorite. So P1 is for athletes. So if we have somebody here who is an athlete, I just had a consultation yesterday with a swimmer who is an Olympic swimmer, and she's on F1 status studying. And I told her, you should just go immediately for green card because has really high level. So she could do P1 as a professional athlete, but also she qualifies as an EB1 extraordinary ability individual. So she can even get green card pretty fast. P3 is for somebody doing activity culturally unique. So for example, we do a lot of P3 for Indian dancers, or it could be for chef. We just have to prove cultural uniqueness in whatever it is, whether it's type of sport or whether it's cooking or dancing. There just has to be some type of cultural uniqueness that we can prove. O visa. Okay, That's another favorite of mine.
I was
So
gonna say that one's your top
yeah,
favorite.
O1A and O1B. So O1A has really high requirements. So that's for somebody in business, engineering, so any field pretty much, if you're considered an extraordinary. So what do we look at? We look at your accomplishment. So it's not as much about the company as it is about you as an individual. We do look at publications, possibly presentations. If you're an athlete, as I mentioned, then we look at your awards, we look at media, we look at how much money you made, different things, and it's very discretionary, so it's never a guarantee. With the O1B, that's for artists, it's a little bit lower standard, so you don't have to be Olympic winner, of course, but it's a lot of I'm trying to think, a lot of actors that we handle, singers, dancers, for O1B. So any type of artist qualifies for O1B. For any of these, there is no deadline. There is no registration, or there is no numerical limitation. So that's why I'm saying sometimes some of these categories are even better than the actual H1B. And, I saw somebody ask the question, do I have to apply for H1B only if I have OPT? No, you can apply for H1B from any of the statuses. So oftentimes you may be a derivative. So you may have, if you have parent here and parent has, I don't know, F1, you have F2, yeah, you can. So you can go from any status to H1B. Typically, we see going students from OPT. Why? Because OPT will give you that 1 year of work permit that you work for the organization. And usually that's the time where you get to know your employer, and employer will say, what do I do to keep you? I really like you. What do I do? They may be familiar with the H1B, but typically they are not. If it's a smaller organization, they're not familiar with the H1B at all. And then oftentimes, the student will pull us in just to explain to employer, because they may be scared to file the H1B. They hear a lot of stories how H1B or foreign nationals are displacing US citizens. And it's not true at all. So oftentimes we are pulled into these conversations just to explain to employer, what H1B is, what are the obligations, what does the employer have to do to file the H1B? But that's just typical situation. But as I mentioned, I had my client from, I don't remember which country, but he came on a visitor visa, had a few meetings, and then decided to go for H1B. So you don't necessarily have to be in F1 status and have OPT to go ahead with the H1B. Okay. What about if I have a bachelor degree in teaching that is already evaluated? I don't think I understand the question. So if you have degree that was found US equivalent of a bachelor's degree, and you have a job offer, you can proceed. So the next H1B season, if you have the employer would be able to do an H1B registration. So that's that. Okay, let's move on. How much time do we have? Richard, how much time do we have left?
Well, I think we planned for about 45 minutes, so I think we have at least 15 minutes, and we can have a little Q&A session and make sure everybody gets your contact information. I see a few people are asking, how can I contact these wonderful attorneys for case-specific questions and the private consultation? Again, the website is visaserve.com.
Sam can put it in. Sam can put in your emails and the website.
I did. So the emails are in the chat.
Yeah, feel free. I'm just going to mention it. We are pretty good, I think, all of us. So it's not just two of us. We are a mid-sized firm. We are pretty good on the email. So feel free to send us an email. I'll definitely answer if it's one or two questions. If you feel you do need a consultation, it's definitely better. And based on the question, I may just tell you it's better to schedule a consultation. Just do mention that you need to get discount for the consultation. So it's $100 that you are paying for consultation. And we'll just forward you to receptionist to schedule it. And typically we just do Zoom consultations, but I never mentioned it. We have office in Ridgewood. We have office in Raritan. We do have office in Florida, as Sam mentioned as well. But I have to say, mostly it's that's a newly open office, but mostly it's just Zoom. We hardly see, because it's, we have clients all over the US. I have to say that most of the time we meet through Zoom. Let me just go. Yes, somebody's asking, and I'm going to go. I quickly want to go to EB3, and I want to talk about green card a little bit.
Right, because you have this non-immigrant status. What's next?
Yes. So I'm not going to spend too much time because it can be overwhelming. So I'm going to just hit really most important points on the green card side. So unlike the H-1B, if you're pursuing the green card and you have I'm just talking about employment. I'm not going to be talking about family right now. It has to be full-time employment. So if the employer is filing a green card for you, it has to be full-time employment. And here, let's talk about that. The company actually here, I would be checking tax returns of the company, because the company will have to show that they have financial ability to pay your salary. So if you're already working there on the H-1B, that's great. Even if they show losses, that's fine, as long as you're already getting W-2. But if not, we will have to show net income on the tax returns. So this is a little different than the H-1B. And we have several categories. So EB1, that's the highest category. And, it's not for everyone, really. EB1A is for someone with extraordinary ability. It's very similar to O1. So for example, I mentioned that swimmer, Olympic swimmer, or I have researchers that have a lot of publications and so on. So that would be them, somebody who has a really high standing in a field and has a lot of evidence. Then we have EB1B, which is outstanding researchers and professors. You do need an employer for that. I forgot to mention, for EB1A, you don't need an employer. You can file yourself. For EB1B, you do need an employer. And then we have multinational managers. And if you remember, that's the category that I mentioned in connection with the L1. So if you're coming as an intra-company transfer manager, or you're coming to open up a new business, you would be able, I mentioned that it leads to green card, and this is the type of green card. So our Indian or Chinese clients love it, because here they don't have to wait for green card for 10 to 15 years. It's immediate. So it's a really nice category. And this is just some evidence that we look at for EB1, as I mentioned, publications, presentations, and so on. So let's talk about EB2, and actually it's going to be EB3 as well. Typically with EB2 and EB3, we will do labor certification or PERM. With EB2, we also have national interest waiver and Schedule I Group 2. So let me just jump into labor certification, because I would say good 90% of people will end up going through PERM or labor certification. So PERM is definitely not our favorite, but the employer has to prove to the Department of Labor that there are no US workers that are qualified, able, and willing to do the position or job. So there is very extensive recruitment that needs to be done. So first, there is a prevailing wage. Remember, I mentioned with the H-1B that I actually can find it. I can determine what the wage is. Here, I can't. I wish I could. I can't. So we have to submit job description to the Department of Labor. Unfortunately, it takes them about 6 to 10 months to get back to us with the prevailing wage determination. Assuming that salary is not too high, then the employer goes ahead and does the recruitment. So they post a position in the 2 Sunday ads in the newspaper. They do job order. They post the position on a website. So there is recruitment that needs to be done, and it's prescribed by law, by regulations. Once the employer determines that no one is qualified, so they receive resumes and no one really is qualified for the position, then there is electronic filing with Department of Labor. Assuming the Department of Labor will certify the case, then the second stage of the green card process is the I-140 petition. And with I-140 petition, we do have to submit tax returns of the company to show they have that financial ability that I mentioned. And also we have to show that our applicant actually meets the criteria that were requested. And then lastly, assuming the priority date is current, is adjustment of status. And it's all about the applicant. So, they do biometrics. The government wants to make sure that they don't have any criminal record and so on. So that's probably the easiest step of the three, I would say. So as I said, this is the most typical path for a green card. Then we have national interest waiver. And I like that because there is no employer needed. You can do it on your own if you qualify. So this is not as difficult as the EB1. You don't need publications or presentations and so on, as I discussed with the EB1, but you need something because you need to show that you have the potential to advance your field, and also the field you're working in is in nation's interest. So, we can be creative, but of course you need to have some credentials. We need to have something that we would argue, why is it that with your work, you would qualify for national interest waiver? But I really like that option because there is no employer involved. So it's also one of my favorites. And lastly, the EB3. So everyone does labor certification. The process that I explained with the Department of Labor with EB3 is required. I'm going to correct myself. Not everyone. Nurses. So nurses fall under EB3. And there is a special process called Schedule A Group 1. And that's specifically for nurses. So they are skipping Department of Labor. They're not doing labor certification because there is a shortage. So it's much easier process for nurses. There is a prevailing wage filed. So unfortunately, we would have to wait for that. But then there is just filing with USCIS. So we call it a pre-certified category. So it's a much easier way than going through Department of Labor. But otherwise, everyone else in EB3, which is someone holding at least a bachelor's degree, or if it's based on if we are doing, which doesn't matter, because within EB3 we have skilled workers, unskilled workers, and professionals. So for professionals you do need bachelor's degree, but it's all same, it's all EB3, so it doesn't really matter. Skilled worker is someone where the position requires at least 2 years of experience. So that's EB3. We don't have here EB4, but EB4 is for religious workers. So Sam, did you talk about R1?
I don't think so. I think that might be the one that we jumped over.
Yeah. Religious workers. That's also a good alternative if you have church or you have religious organization that is willing to do your sponsorship. And then, EB4, which is directly related to R1. So whoever has R1 would do, after 2 years, would do green card through EB4 as a religious worker. And of course, there is no labor certification. So it's really nice. And then the EB5 is the last category. That's for investors. You need to have a lot of money for that. Okay, we talked about. Okay, so this is our website. Now let me go to questions. Okay. Okay, Elizabeth, I'm not sure I follow the question about the nurses, registered nurses. So yeah, it would have to be RN with the license. Okay, good question about who can sponsor you for EB3. Family members cannot. So with H-1B, you were asking me who can be, what type of company can sponsor. So even a family member could potentially, uncle or somebody, but with the green card, no. They're actually, Sam and I have a case right now. It's a big problem because the father has a huge company. So it was a bona fide position, but they didn't disclose it. There's actually a question on the labor certification form. Do you have any familial relationship? So, because we are proving a bona fide recruitment and so on, it's really hard to establish that if there is a family business. So any type of green card, the employment-based green card should not be done with the family. So that's very important.
Yeah, this next question is a good one too. If somebody filed for me, does the H-1B apply to me, or can I still do the H-1B? And it's definitely a good idea to keep your options open. Some family-based petitions do take a long time, and you can apply for multiple avenues and multiple options at the same time. Typically, there's no issue with that.
So that's a good point, Sam, that it just depends what relative. So if it's US citizen sister that applied for you, you're going to be waiting for 14, 15 years. So you better have a non-immigrant status valid. So you should be applying for H-1B lottery for sure. If it's a US citizen parent that is applying for you, and you're single, the wait time is about 5-6 years. And again, just filing that does not give you any status. So you have to have underlying non-immigrant status. So unless it is a spouse that is a green card holder, US citizen that is applying for you, you need to make sure in all other circumstances, you need to make sure that you continue your non-immigrant status. So yes, in that case, you definitely want to do the H-1B. Let's see. How long does it take for EB3? That's a good question. So labor certification, I would say about close to 2 years. I-140, which is a second step, you can premium process where you pay government $2,500. You can have it done in 2 weeks. And then adjustment of status, I had cases where I filed it and in 3 months people have green card, and I had cases that it took 1 year. So I would say adjustment of status, it's about 1 year, unless you're from India or China, where you cannot apply for that adjustment. So it may be taking a long time. For EB2, unless you're from India or China, I'm just going to talk for other countries. It's pretty much the same. EB2 and EB3 is the same. Okay, since my sister is a citizen, it took about 10 years to invite me. So I'm preparing for the I-130 so I can prepare something else after applying. Yeah, so as I mentioned, through US citizen sibling, it's taking about 15 years. So, the priority date, even if it's approved, I-130, it doesn't mean anything. The priority date needs to be current for you to file adjustment of status. Only that gives you right to stay and be authorized to stay in the United States. In between, you have to keep your non-immigrant status, whatever it is, whether it's F1 or, you need to continue your status. What is the probability to get approved on EB2 or EB3 after being on J1? It doesn't matter. It really doesn't matter. As long as, again, you continue your status. And if you had J1 in the past, very important, I think Samantha mentioned it, you need to check whether you are subject to the 2-year residency requirement, because if you are, you cannot proceed with the H-1B or green card. So you need to file for a waiver of the 2-year residency requirement, or you have to go back to your home country for 2 years. EB3. I just want to make sure we don't provide, you understand, we don't provide employers. So we only help with the actual immigration process. We do not provide, we are not staffing agency. So I don't have any contacts for employers. People come to us, they already have job offer, and we just process the immigration matter. And you can feel free to unmute yourself if you have question and just ask question. So there is a question, my brother and his wife are engineers and they want to come. So this is definitely a specific one. So this would require a consultation. I would need to see both of their resumes and just go in detail over everything. This is a perfect example that would require a consultation. What are the chances of rejection of EB3? There is always, if any attorney will tell you that it's a guarantee, run away for sure, because there's just no guarantee. We can do our best, but with that being said, if everything is done properly, there should be no reason for rejection. But again, there is never a guarantee, because what could happen is if you do labor certification, that the company actually will find qualified worker when they do recruitment. If that happens, then you cannot even continue with the process. So it's hard to say. What is regression in EB3? Maybe retrogression. So retrogression is only for our Indian and Chinese clients at this time. Because why? There is a visa bulletin that is published by Department of State each month. And they do have China, India, Mexico, Philippines, and all other countries. And typically, India and China for employment-based are retrogressed. Why? Because they just have a lot of people applying from those countries. That's why there is a kind of like a wait list. So as I mentioned, India is the worst. It's about 10 to 15 years of wait time. So that's why we say there is a retrogression. For family-based cases also. So I mentioned if you're applying through your US citizen sibling, it's about 14, 15 years. If you have a US citizen parent or even green card holder parent applying for you, it's about 5, 6, maybe 7 years to get a green card or to be able to file adjustment of status. Do you know how much the employer have to pay for requesting an international employee? I think maybe you're asking for the H-1B. Monica, are you asking?
I think he's asking about the legal fee, not the legal fees, but the filing fees for the employer.
Okay, so the filing fees are $460 for H-1B. If you're selected and then when the employer is filing, it's $460. That's a basic fee. Then there is a fraud fee, which is $500. Then there is a training fee, which is either $750 or $1,500, depending on the size of the employer. If the employer has 25 or less employees, $750. If the employer has more than 25, then it's $1,500. And there is optional premium processing, $2,500, but that's optional.
And just to clarify, your firm, if they're handling an H-1B case, would be assisting both the applicant and the employer to make sure that they're meeting all of their filing deadlines and paying all the necessary fees,
that's a
right?
perfect question. So it's a dual representation. So yeah, we would be representing the employer and the employee. So for example, I just had the situation this week that I was dealing with, where of course we're representing both. And the employee told me, please don't take my employer, and they shared something with me. Well, that's a problem. This is creating a conflict because I cannot have employee telling me secrets and they don't want to, me to disclose it to the employer. But yeah, it's a dual representation. The same goes for family-based petitions. So when I'm representing, I don't know, US citizen mom and the beneficiary, it's a dual representation. Or if it's a marriage case, I'm representing both husband and spouse. And if they're getting divorced, then there is a conflict and I cannot continue representing either one.
Right. You represent the whole family, or in the case of a company, you represent the whole company, including the potential new employee.
Yeah.
Yes, exactly. So let me see. Sam, did we, to associate degree?
I think there's a lot of questions about, whether certain degrees would count for purposes of the H-1B, and it's super important to do the credentials evaluation to be able to determine that. With the H-1B lottery being in March, you do have time, but I wouldn't wait too long. Maybe it's a good idea to start that soon so that you know ahead of time what your plan could be. It may take them a couple of weeks maybe to put it together or for you to get all of the necessary documents together. So I wouldn't wait on that. I would do it soon.
Yeah, we usually we tell people get back to us sometimes in January, because, it usually
takes time.
Yeah, we have a lot of people that we help. Employer can do registration on their own, or oftentimes they ask an attorney to help with the registration, because what my worry is with employers that they do registrations for employees and maybe they don't necessarily even qualify for the H-1B. So usually we do quick analysis with whether the position qualifies for H-1B, whether the person qualifies for the H-1B, and then we do the H-1B registration. But the employer can also do registration. Important thing that I forgot, and that's really important. If you have several companies that are interested in you, you can have several companies doing H-1B registration. That's going to increase your chances, but the companies cannot be related. So it's not like all of the 3 companies, for example, are sister companies. So that's the only thing. But we had individuals that had 3, 4, 5 registrations in. So that's just going to increase your chance for sure.
Yeah, can I have a question?
Yes.
Sorry, interrupt you because we talk about the EB3. So it means like EB3 have a lottery about that. So it means like I think it have a limit. I think it have a limited EB3. I think 10,000 visa every year. So, but some case is success. It means like get your green card is okay. But some case it's what it means like have a 2 options. One, you get the permit, work permit, and about the social security before you get your green card. And some case you get the green card before that. So if you get the work permit and you get the social security and you work with that company, but what happened after if you fail the interview? Because it means at that time you not have you not still have the F1 visa status. And what happened about that? And the other thing is it mean like how long take the EB3 process? It like the 2 year, 3 year, have something like that.
And what country you're from?
I'm from Vietnam. But if you change the status in the US, I think it doesn't matter what country.
No, it does matter.
Yeah. But
it's very important what country you're from.
Yeah, I'm from Vietnam.
So there is no retrogression. So EB3, should take about within, I would say, 3 years. You should be done. You typically would not have an interview. In the past 2-3 years, they stopped doing interviews. So pretty much you just get green card in a mail. You're right. When you file adjustment, you first get work permit, and then you get the green card. I've had some cases where people didn't get work permit and they just got green card immediately. Interview, typically, if you get interview for employment-based case, that means that there is some issue. Because right now they're waiving interviews for employment-based cases. You need to be in legal status. So if you filed your green card while on F1, you need to maintain your F1 until the time you at least file adjustment of status. That's super important because you cannot have any gap. The most you can have is 180 days. That's it.
And I think one part of his question was asking, in case for some reason the EB3 gets denied, then how does that affect his status in the US and his employment relationship with his current employer?
Well, it all depends what the underlying status is. And
Right,
that's
because
why
maintaining that, he should be okay to fall back on it, right?
correct. So our rule, we always, and you know, that's not for everyone, but I tell everyone, please maintain your status until you get your green card. The same what I mentioned with asylum. It's always safer, and it's the same for the green card. So if you have H-1B, maintain the H-1B until you get your green card. If you have F1, maintain that F1 until you get the green card. Because, you know, if the green card is denied, you always have then something to fall back onto. If you don't have status, and I see it with a lot of people, especially students, you know, I see horror stories. For example, marriage case, which should be simple. Student files for a green card, should be no problem. But, you know, they lost the file. There was a request for evidence. The government never got it. Bottom line, the green card was denied. And now, you know, the student just stopped going to school. So now this is a problem. And especially if they place them in removal proceedings. So always safer to stay in legal status until you get your green card. It's a safer, definitely.
I have a question continuing with this. Even though if you go back to your country to have, after you file all the papers for the AB3, so you are still in the student visa, but you go back to your country waiting to get approved the AB3?
Yeah, you can
That's good.
definitely do that.
So you are just talking about keep the status if you are in the country, right?
Yes. Yeah. So if you decide that you're going to go back, you definitely can. And you wait in your home country. And then the difference is you will process the EB3 case or EB2 or whatever it is through the embassy, US embassy abroad. Yes, you can do that.
Okay, so it doesn't matter if your status is still on or not. Imagine that now I'm in the F1, then I apply to the B2 visa, and then I'm just waiting for the interview in the embassy. And I don't get approval in the B2 yet. If I go to the embassy, it doesn't matter.
Are you talking about B2 or EB2?
EB2.
Yes. So if you have F1, you then decide you're applying for EB2 and you leave, embassy will not deny your case unless there is some problem. Okay. Because EB2 is a green card. So you're applying for immigrant visa. I personally have never seen a denial unless there is a problem. So what could be the problem? Let's say you have fraud in your history. Let's say you lied on the application. So then they would deny it because there is a fraud determination. Let's say you have criminal history, could be denial as well, or refusal. So EB green card typically would not be denied just like that. It's not like F1 or it's not like B2, which is a visitor visa that can be denied, you know, just like that. No, for green card, it doesn't work like that. There has to be some reason, and they actually have to put law or regulations under which you are refused. So, you know, if you, for example, if you overstayed your status in the US, you then leave and you're waiting for your green card, you know, they could deny it because you overstayed and now you're barred for 3 or 10 years. So.
Okay, thank you.
You're welcome.
So for applying for appointments, through the website or through the emails?
What type of appointments?
I think with
Appointment
us.
With you.
Oh, I thought for the consulate.
No, it's not for the group.
Yeah, you know what? The easiest, just send us an email. You can go on our website, you can call, or you have our emails. Feel free to shoot us an email. So whatever works. Okay. Anyone, any questions? So again, the key today was just to get you just to start thinking about what you want to do. Immigration is very complex, and we kind of threw at you a lot of information. So again, today was just give you an overview to kind of understand what immigration is about, difference between dual intent visa and difference between purely non-immigrant visas, and just to show you that there are different options. So, you really need to think outside of box, and please start planning. Don't wait until your status is almost over to then think about what I'm going to do. You really need to start planning. If you want to do E2, you need to establish the business and so on. So again, purpose of today was just to kind of, open your eyes and,
Establish what kind of business? I'm so sorry. I'm sorry for interrupt you. Establish what kind of business?
Whatever you want to do. Any.
Okay, so if I already have a business and I'm paying taxes since 3-4 years, and I'm paying personal taxes since 3-4 years, but of course it's a small business, it's not a big business. What is my chances?
This would need a consultation.
Okay.
Yeah. How many? Okay, somebody's asking me about overstay, so this is good. As a student, if you have F1, let's say, I don't know, you violate your F1 or you finish the school and you never did anything and you now have no status, you don't really accrue unlawful presence, because as a student, you are admitted for DS, duration of status. So it's a really nice exception that students do not accrue unlawful presence unless there was a decision. So for example, if you did a reinstatement that was denied, then you start accruing unlawful presence. What does it mean? If you have unlawful presence of more than 180 days and less than 1 year, and you leave the US, you're going to be barred for 3 years to come back to the US. If you accrued more than 1 year of unlawful presence, you're going to be barred for 10 years once you leave the US. So, but as I said, for students, because you are DS, you really don't accrue unlawful presence. Even though you would be in unlawful status, you don't accrue unlawful presence. Okay.
All right. Well, thank you so much, Ludka. I'm not sure if there's any more questions. We can stay connected for another few minutes in case some extra questions come in through the chat. I appreciate you sending and displaying your email address. And that's also available in the chat, info@visaserv.com. I also appreciate you re-emphasizing the importance of maintaining your status until your new status is approved. That is a common question and a common debate that we have internally a lot with students, prospective students who are applying for F1, and former students or current students who are maybe finishing their program and waiting for their next status to be approved. It's important to maintain your current status just in case. You never know what's going to happen. So thank you so much. And as I mentioned before, at UCEDA International, we have served thousands of international students over the years, especially F1 visa students that are studying intensive English programs. There are a lot of different pathways that somebody can take after the intensive English program toward a college or university or employment. And there's a lot of those pathways we've discussed today. For your case-specific issues, please consult with an attorney. You can speak with one of our academic advisors who can lead you to an attorney near you. And of course, visaserv.com is one of our preferred partners that have helped us with a lot of different cases. And if you have any questions, they're more than capable in helping you with your case, I'm sure. So thank you again, Ludka and Samantha, for all of your
Oh, you're
support.
welcome.
Yeah, you're welcome. Thank you for having us.
Yeah, and thank you
Excuse
everyone for
me.
questions. It always makes it more interesting with the questions. So thank you for listening at this hour.
Excuse me, I have a last question.
Sure.
You submitted by chat. I don't know if maybe you saw it. I'm a F1 student, but I'm married with my wife. She came with a visa, like B1 tourism visa, but she right now it's in overstay. I would like to apply to EB3 to get the green card, but I'm not sure if his status will affect the process to me.
No, it will not.
Sure. So should I just get that status for me, and after I'm a citizen, can I use?
Not even citizen. There are ways even for you to do it as a green card holder, but you know, your spouse would need a waiver, 601 A waiver, which is a hardship waiver, possibly, or you wait to be US citizen. But yeah, you can do your own individual green card and go from there.
Should I mention her status, or just it doesn't really matter?
I mean, you can, but there is no question about it. So, you know, why would you?
No, I'm saying because, well, in the EB3 process, as sometimes it's a familiar
There is
visa.
no question. There is no question about it.
Okay. Well, thank you.
You're welcome. Okay.
All right, I think that's it then. Have a great night, everybody, and thanks for tuning in and connecting tonight, and for your participation. I think this got a great response, and we're going to have to make this a regular event. I think at least once or twice a year to invite VisaServ to join and present to our students at UCEDA and to our audience around the world. Thanks again for joining, everybody.
Our pleasure, and again, thank you for having us.
Yeah, thank you. Good night, everybody.
Thank you. Good night.
Good night.